Okay, we'd like to welcome all those who are in attendance at this moment. We will be starting shortly with our lien law webinar covering the state of Arizona. I apologize. During the webinar, you are able to ask questions. We will cover that. If you were to click your icon and type in whatever question that you have for the presenters, it will be seen and we will address those at the end. But again, we'll be starting shortly. Please feel free to sit back, relax, and enjoy. Again, we do want to thank everyone for attending. If you would like to, just to test the system to see if you're able to ask questions, if you were to click on your icon as an attendee, type in a question. There, we see a hand raised. Great, fantastic. You should be able to type in your questions. You not going to be able to talk during this period, but you will be able to type in questions that you may have, and we'll be able to observe it. Thank you for the test. And just to be sure that everybody can see the PowerPoint presentation currently, I am going to ask one of our panelists, are you able to see the Arizona lien loss summary on your screen?
Yes, we are, Gregory.
Fantastic. Well, with that being said, we do welcome everyone to our Arizona lien loss summary. My name is Gregory Gregg, and I am the Client Retention Specialist with Nationwide Notice Incorporated, as well as the facilitator of this event. This webinar is scheduled for approximately 1 hour, which includes a 10-minute Q&A session after the presentation. You're welcome to ask questions via chat, which will be addressed by our presenters at the end of this presentation. In order to comply with the suggested time frame, as well to ensure that all are able to return to their busy schedules, any questions not addressed during this webinar will be addressed by way of instructions provided at the end of the webinar. Welcome all to the Lien and Bond Summary for the state of Arizona, hosted by Nationwide Notice Incorporated and presented by Wagner, Falconer, and Judd, Ltd. Nationwide Notice is a full and self-service preliminary notice and lien service company. We can establish and assert your lien rights on any project in any state. Our groups of highly trained professionals are experts in securing your lien rights to ensure that payments are made to you according to your terms. When it comes to getting paid, securing your lien rights can make all the difference. Now let's introduce our presenters of Wagner, Falconer, and Judd. Lawrence Gildem is an associate attorney at Wagner, Falconer, and Judd and practices in the areas of commercial litigation, commercial collection, and commercial construction law. Lauren assists clients with enforcement of their lien and bond rights. She represents industrial and constructional material suppliers, helping both small and large businesses collect their receivables and enforce their contracts, utilizing the resources of WFJ and its affiliate law firms around the world. Lauren has presented her construction knowledge and expertise in many educational seminars and workshops with our clients. Don Reich is a shareholder at Wagner, Falconer, and Judd and has been practicing law for 18 years. Dan focuses his practice in the areas of commercial collections and business litigation with an emphasis on construction-related claims involving construction disputes and mechanic lien and payment bond claims. Over the years, Dan has been a frequent speaker at seminars and workshops involving construction and collection issues and other topics. So with that being said, I now hand over our webinar to our presenters, Wagner, Faulkner, and Judd.
Well, thank you, Gregory. Audience, it's a pleasure to be here. I will be speaking for the first half of our presentation, followed by Dan Reich, and then we will take questions at the end. Good morning if you're in Arizona, I believe. Good afternoon for everyone else. We are here today to talk about lien and bond rights for Arizona. We definitely will be talking about notice deadlines and requirements that apply specifically to the state of Arizona. But part of our discussion will focus on matters beyond the state of Arizona, matters that apply to lien and bond claims from California to Maine and all the states in between. We want to do this because we think it's important for you to understand the notice deadlines and requirements for the state of Arizona, but more importantly, understanding the basics of the underlying principles of bonds and liens gives you a better grasp on these remedies and how your state or your company may be doing business, whether it's Illinois, Oregon, or wherever your project might be. So let's move into the ladder of supply. This list of information here is some of the information that's necessary for dealing with a mechanic's lien or a payment bond claim. Some of you may wonder, what good is a mechanic's lien claim? What good is a payment bond claim? Well, there's special tools that only apply to the construction industry. Some of you who have credit experience may know that if your company sells equipment or a product to another company, typically your only remedy is going to be a lawsuit against that customer. If they will not willingly, voluntarily pay, that's your remedy. You file suit and it's a breach of contract claim, and that's what you have. But if your customer does not have the funds, even if you're able to get a judgment, you have a problem. The lien and bond remedies in the construction industry in the state of Arizona give you something outside that normal toolbox. It gives you the opportunity to file a lien claim or assert a bond claim where you can deal directly with the owner or the general contractor or other parties in the chain of parties that hopefully do have money, which give you a remedy above and beyond that contract claim against your customer. Lien and bond claims typically apply to 4 different types of projects. Number 1, private projects. That would be homes, office buildings, warehouses, hotels and motels. Number 2, public projects. Construction projects owned by the county, city, public schools, courthouses. Number 3, federal projects. That could be the Army, the Navy, federal buildings, military bases. Number 4, hybrid projects, a little bit of public, a little bit of private. Those are a mixing of the private and public coming together. So as I've indicated here, you're going to need to know what type of project you're involved in. Is it a public? Is it a private? Is it federal? Next, that's our lovely light rail train outside our building. Sorry for that. The next item is to identify the state. And this is simply, it can be simple. If your project is clearly in the state of Arizona and your customer is in the state of Arizona, but that might not be the case. You may have a customer in California with a project in Arizona. Just because your customer is located in the state does not automatically mean that the project is located in the same state. We recently had a client that requested a lien be filed in Pennsylvania when all of the invoices and the customer itself were in Pennsylvania and being sent to Pennsylvania. However, the project was actually located in Phillipsburg, New Jersey, just over the Delaware River. The lien filing deadlines are different in those two jurisdictions, and the client didn't even realize that this involved New Jersey until engaging us to file the lien, which was problematic. But I use that as an example to highlight you need to know where you're working and who you're working with on your project. The next item is to determine the chain of parties. That is from the contract tier structure. Are you selling to the general or an owner or a subcontractor? Once you know the type of project, the state you're located in, and where you fit in the chain of parties, you can figure out what rules apply. Is it a public project in Arizona, a private project in California, etc.? So let's move on to this contract tier structure slide. This is kind of just a graphic to help you explain how the contract chain applies to your lien rights. It's crucial in determining whether you have lien rights. The owner is at the top of the project. Typically, a general contractor falls right below it, or you may be the general contractor. You may be dealing directly with the owner on the project. However, oftentimes there are other parties involved, and so we have to travel down the chain. So a subcontractor, the technical definition of a subcontractor is one who furnishes labor and materials. Typically is installing the material that a sub receives from the supplier below. In some cases, you could be a supplier selling to a subcontractor of the general contractor. In the heating and air conditioning industry, oftentimes our clients are selling to a mechanical subcontractor of the general contractor. Are you selling to the GC or are you selling to a sub? That does make a difference. If you are a material supplier selling to a material supplier, that's not a good spot for lien claim rights and bond claim rights. In most states, including Arizona, if you're selling equipment to an equipment supplier, that's just a reselling of equipment. So you're typically not going to have mechanics lien rights. In that situation, if you know you're selling to someone who's just going to resell your equipment, you are going to want to look at other options when you engage with that customer. You know, perhaps securing a guarantee from the general contractor, or just being aware that lien rights don't apply. And so you need to look deeper into your customer and the solvency of the business. You know, how are they doing? Because if they can't pay you, that may be, you know, the end of the road. So who has the right to file a lien in Arizona? In Arizona, if you sell to the sub of the general contractor, you're going to have lien rights. It's not always the case. In some cases, in that situation, you actually will not have lien rights. But in Arizona, if you're selling to a sub, you will have lien rights, unless, of course, that sub is a material supplier just reselling your equipment. If you're contracted with the owner, if you're contracted with the general contractor, and if you're contracted with a sub, you are going to have lien rights. Let's talk about who doesn't. We'll dig a little deeper. Who does not have lien rights? We're going to circle back to just drive this point home. There are a couple of states where the material supplier selling to a material supplier has lien rights, such as Texas, Ohio, I recall, but in most states you're not going to. So if you're selling to a minority broker or a company that is just buying and reselling the equipment, identify that in advance. And In this state of Arizona, you are not guaranteed lien rights if you sell to a subcontractor of the general contractor. So you're going one tier lower. The statutes and case law suggest you may have the lien rights there, but we don't, at our law firm, we don't recommend that you rely on those in that situation because it's not altogether clear. You're just too far down the ladder, and those rights aren't specifically protected. Okay, let's jump to preliminary notices. Who to notify that you're on the project. Some states do not have notice requirements, but Arizona does. So very simply, the notice must be mailed out to the owner within 20 days of your first date of labor or material. You have to know who your owner is so that that information goes to the correct party. If you send notice to the incorrect owner, it's going to be invalid. Who are you going to notify? Who gets the notice? Similar to most jurisdictions, if you're direct with the owner, you do not need to send a notice to the owner, but you do have to send notice to the construction lender. If you're contracted with a general contractor or a sub, you have to notify the owner, the general, all parties above you, and the construction lender. The construction lender could be difficult because you may not know who that party is. Very likely you have no idea. If it's a renovation or a rehab project, there may not be a lender. If it's a new construction project, a new office building or a new hotel, very likely there is a lender. So arrangements would need to be made to conduct a title search or a owners and encumbrances report, so you can determine who the owner is and the lender, and to send that notice to the proper party. Okay, let's discuss serving the notice. Serving the notice is important because if it's not done correctly, you haven't preserved your lien rights. If you don't do it timely, you haven't protected the value of those labor and material that you've already provided. So notice, excuse me, notice is considered to be served on the day it's mailed. This is sometimes called the mailbox rule, and you need to serve by certified mail. So, okay, let's use today, May 22nd. If you ship your equipment today, that's your first day of furnishing, then day one is going to be tomorrow. We've got 9 more days in May and then 11 more days in June. So this would come up to your deadline would be Tuesday, June 11th of serving that 20-day notice to preserve all of the work that you have provided on the project. Your notice would need to be mailed by that 20th day, June 11th, not after the 20th day. And you can serve a late, well, first you can serve early. You can serve before the first date of furnishing labor material. That's fine in this jurisdiction. And you can serve late if you realize your process and protocol fell through on this job and you have not served notice. You can serve it late, and we would say do serve it immediately when you become aware of that. However, it's only going to cover those labor and materials that were provided the 20 days prior to when that notice is served. So if you've got a big gap of time, you did a bunch of work, say you did 50 grand worth of work, months go by, you're still on the project, but you're going to do more work. You realize you didn't serve that notice. That late notice is going to protect the remaining balance that you're providing on the project. It won't cover that original $50,000 worth of work. Also, there is a proof of service affidavit that shows that you did serve the notice and you have to identify the type of services you've provided, and you want to take care to be sure that you also trap those, or you collect those signed certified mail receipt cards or the signature pages when you send that affidavit out, to match those up to the job file. Because, you know, what we see is if someone's trying to contest the validity of your lien claim, they're going to say, well, we didn't get notice. And that this way, you're going to be able to say, look, I've got a proof of service affidavit. I've got signed certified mail receipt cards. I've got the backup to prove that, no, you did receive notice, and we have a valid lien claim. Okay, so moving to the 20% rule. This one's fun. In Arizona, if the original contract amount ends up growing and the work you do exceeds that original amount by 20%, you need to give an additional 20%, an additional preliminary notice. You know, we're referring to it as the 20% rule. So when should you do that? It's not quite clear under the statute. So what we recommend is when you know your contract has grown to over 20% of that original balance, go ahead, serve that new 20-day preliminary notice that incorporates that full value, that full contract value. If for some reason that doesn't happen, when you start furnishing labor or materials on that additional amount, that's when you're going to want to, again, make sure you serve that preliminary notice to trap, or not to trap, but to preserve your lien rights over that work that you're furnishing. Okay, so now let's move to identifying and verifying the property owner. In Arizona, the owner is required within 10 days of receiving that preliminary notice that you've sent to secure your lien claim over the labor and materials you furnished, they have to provide a written statement to you listing the specific information about the project, including a legal description of the job site, name and address of the owner, the general contractor, any construction lender, and whether a payment bond has been furnished for the project. So once you receive this from the owner, you should incorporate this into your practice, that you just take that information and you compare it to your job file, because perhaps some of your information wasn't right. That happens all the time. This has, from the owner, their information, you're going to compare it to who you served, all the parties, all the information, the construction lender. You're going to make sure the accuracy of that. And then if you have any mistakes, you need to reserve your preliminary notice. You draft a new preliminary notice and you get that out within 30 days after receiving the corrected information. So you got to move quickly on that. You're always just going to want to make that part of your process. Here's a sample preliminary 20-day notice. It's a 3-pager. So these get involved, but you're going to see on the left side here that we've got owner, original contractor, lender, who you are, and who you're doing business with. Then what are you furnishing? What type of, is it HVAC equipment? Is it scaffolding? Is it plumbing equipment, electrical wire? What are you providing? And then where is it happening? Also, the contract value, the estimated total price of the labor and materials. And then on the second page here, this notice to the property owner, that's what tells them, okay, you have to, within 10 days of this notice, advise this claimant who's letting you know, hey, I'm on the project, I'm working here, I have lien rights. You have to notify them if any of the information they provided on page 1 is inaccurate, and then correct it. And if you don't, the property owner is waiving their rights or any defenses that they might have to not timely receiving information. Here's page 3, which is that acknowledgement that you're asking them when you send the prelim that they would acknowledge receipt. And that just helps to, paper your file that you did what you need to do to secure your lien rights. So now let's dig deeper. Now that we've talked about the preliminary notice and some of these deadlines, let's talk about the mechanics lien itself. Okay, so the mechanics lien, what actually is it? Well, it's an opportunity to encumber the property where you're notifying others of your claim. It's actually going to go on the title of the property. So the owner cannot secure new financing, cannot sell the property, can't really do much in terms of transferring title while that lien is there, because it's encumbering the property. It's sitting out there as there's a balance that needs to be paid before anything can be done. And the lien is involving the other parties beyond your customer. It's kind of pouring gasoline on the fire that is your receivable. It has not been paid. We're letting everyone know about it. And hopefully we're kicking up dirt so that we can get paid. So what is the amount of your mechanics lien? Well, that's going to be the reasonable value of work or the agreed upon price. You're not going to include any additional amounts, not attorney's fees, not interest. You don't include that in a mechanics lien. Next, this lien is a double jeopardy lien. It's not a lien against funds claim. And so you are going to be able to go against the owner even if they've already paid down the contract chain for the work that you've done. The owner's real estate is subject to that lien claim, and all of even if they've already paid those contract funds. So, but the lien is only applicable for what you trapped, or I shouldn't use that word trapped, for what you properly noticed with your preliminary notice. So for the 20 days prior to your notice, that's what's trapped, or that's what's included in your mechanics lien claim. So what are the deadlines to file your lien claim? Well, it's going to be 120 days after the completion of the project. And that completion is defined as the date that is 30 days after final inspection and written final acceptance by the governmental body that issued the building permit for the project, or if there is a cessation of labor for 60 consecutive days, whichever occurs first. So we do not recommend waiting for the last sub on a job before you consider whether you have lien rights or the completion of the project, the entire project. There could be a 60-day lapse of time where no one's working on that project, and you just might not be aware of what's happening there. So the default deadline that you're going to want to use is 120 days from your company's last date of furnishing labor and materials. Now, a notice of completion may be filed at the courthouse by the owner. And if that happens, that actually shrinks the deadline for you. That deadline to file the lien would be 60 days after the notice of completion is filed at the courthouse. So if you have correctly served your preliminary notices, the owner, after filing this notice of completion with the courthouse, has to give you a copy within 15 days to let you know, hey, completion has occurred. I'm shortening your deadline to 60 days. So it could be that when you get that notice of completion, you only have 45 days to file your lien claim. So it is highly recommended that anytime you receive a notice of completion, you immediately look at your job file to see what's the status of payment. Do we need to proceed with the lien? And I would say just for comfort's sake in dealing with your attorney who's going to be filing this lien for you, you want to give them ample time to do that. 30 days is a comfortable amount of time for them to prepare the lien, make sure the legal is accurate. There's always unexpected hiccups that can come about when you're filing a lien, since it needs to be exactly precise, and unexpected information just comes to light at the ninth hour. So you want to give some time to do that. As I previously mentioned, that double jeopardy lien claim is what you have in Arizona. In some states, there is a lien against funds claim. And a lien against funds means your mechanic's lien would serve to trap money that has not flowed from the owner down the contract chain. So in that situation, it's it's time sensitive. As soon as you're not getting paid, in another state, you're going to want to file your lien right away, because if that money flows down the contract chain, it's gone. If you don't trap the money, you don't have that additional remedy. Your mechanic's lien is kind of, not worth anything. It's not really enforceable. But in Arizona, you get to have this double jeopardy lien, which is really great, because even if the owner has already paid your customer or the general contractor, the owner can be obligated to pay twice. And, sometimes that happens. Sometimes they'll pay you and then they'll deal directly with their GC to try to come to a resolution, or maybe they're already starting to get involved with litigation because there's been change orders and what have you between the parties. And then what you do need to track for your action items once you've filed your lien is your deadline to foreclose your lien. So in Arizona, a foreclosure action lawsuit has to be commenced or initiated within 6 months after the date your lien is filed at the courthouse. So if you're going to pursue that, if you want to use your lien rights, you have to, and you haven't been paid prior to that foreclosure deadline, you have to initiate suit. Otherwise, it's as if you just kind of forfeit your rights. You walk away, because your lien's worthless if you do not foreclose the lien prior to that lien foreclosure deadline. So you're going to want to calendar the file and make sure that you make a decision on that at least a month prior to your lien foreclosure deadline, because filing your attorney's going to need some time to prepare that lawsuit and to make sure that they're serving all the appropriate parties, because you'll need to bring in potentially all other lien claimants into that suit. So by month 5 after you file you're going to want a calendar maybe for month even 3 or 4, and then you have to make that decision by month 5 whether or not you're going to file a suit. So with that being said, I am going to pass the presentation over to my colleague, Dan Reich.
Thank you, Lauren. Let me make sure. I'm assuming at this point you can see we're on slide 17. Is that correct?
That is correct.
All right. Thanks, Gregory. So I'm going to discuss a couple of additional remedies for private projects. Again, these are projects that are privately owned, skyscrapers, commercial developments. These are non-government projects. So on a private project, the general contractor has the option of filing a bond for that project, a payment bond for that project. What that does is that transfers your lien rights from a claim against the property to a claim against the payment bond. It is not normal, so I don't want you to think that this happens frequently, but it may happen on larger projects. If so, as far as a claimant's responsibilities to notice the other parties, notice the owner and general contractor, it is the same requirement as the notice required to preserve your lien. So you are required to give the preliminary notice within 20 days of your first date of labor or material. As Lauren mentioned, if you do give that preliminary notice, the owner is supposed to provide you within 10 days of receipt of that notice project information. And that project information should include information relating to the bond if a bond was filed on the project. The bond was on the project. Then at the end of your work, your last date of labor or material, and you remain unpaid, you are required to give a notice to the general contractor and the owner and the surety if your contract is with a subcontractor. So the final bond notice is not required if your contract is with the GC. If your contract is not with the GC, you need to give notice within 90 days of your last date. What that does is that will then trigger the bond procedure with the surety. The surety will likely send you a request for additional information, and they will attempt to resolve the bond claim short of you filing suit. If you need to file suit against that bond on a private project, it must be started within 1 year of your last date of furnishing labor or materials. Another remedy that's available on private projects is what's called a stop payment notice. I do not want to make this too complex, but I do want to alert you that this is an additional remedy that you may have on private projects. As Lauren mentioned, if you file a lien, your lien is against the property, and you have the right to foreclose on that. It is a double jeopardy lien, which means that even if the owner has paid the general contractor, you are still entitled to assert the full amount of your lien claim. What the stop payment notice does is it freezes funds, or it may freeze funds that are in the hands of the owner or lender. Similar to what the procedures are related to liens, it depends on where you fit as far as a supplier or a subcontractor in the contract tier. If you are too far down the contract chain, if you are a sub to a sub to a sub, you do not have the ability to proceed with that stop payment notice. Additionally, if you are a material supplier to a material supplier, you do not have the ability to serve the stop payment notice. There are two types of stop payment notices. One is a bonded stop payment notice, and for lack of a better way to put it, the other one is a regular stop payment notice. So if you send notice out to the owner and lender of a stop payment without obtaining a bond, that would be deemed a regular stop payment notice. That would be like the form or the piece of paper you send out for the 20-day preliminary notice for a lien. It's similar to the regular stop notice or the stop payment notice. The other option that you have that will carry more weight as far as freezing funds the moment that stop notice is received is bonding that stop payment notice. In order to bond a stop payment notice, it is required to the claimant, who's ever asserting this right, to obtain a bond from an insurance company equal to 1.25 times the amount of your claim. This is not normal, but it does give you more remedies, more rights, if you've got a larger receivable on the project. If there's a, if this is a high profile, large contract that was awarded to you and you are not receiving payments, bonding the stop payment notice may be something you may want to look into, because that will freeze up the funds that the lender has. So what is the impact of the stop payment notice? If a bond was furnished on the project, again, if a bond was put in place by the general contractor for a private project, the lender can ignore the stop payment notice. Okay, your claim is going to be against the payment bond, and you will have the ability to collect on that from the surety, and the lender can, release the funds. If there is no payment bond on the project and you send out a stop payment notice, the owner is required to withhold the funds. But the construction lender can ignore the stop payment notice if the stop payment notice is not bonded. If it is bonded, the construction lender is required to freeze or to hold those funds. With regard to serving the stop payment notice, I guess our guidance, our takeaway here is you can never overserve a notice. If you are a sub to a sub on a project, you want to serve the notice to everyone above you in that contract chain. So if it was a stop payment notice, you would serve the lender, the owner, the general contractor, and the sub. And then, as I discussed, if it's a bonded stop payment notice, you are required to get a surety bond first. With regard to the stop payment notice, the key takeaway that I want you to be alerted of is that you still have a deadline of 20 days, and the regular stop payment notice form does need to list the dollar amount. That is similar to the lien notice, the 20-day lien notice. It is similar to the notice that's required if a bond is on a private project. It's unfortunate. Most of our clients do not like listing the dollar amount on these notices. Some states require that your contract amount be listed. And this is one of those states, unfortunately. If you are going to be, if you're considering a bonded stop payment notice, you should do so early on in the project. It's going to take time. It's not something that you can just, fill out a simple form and obtain a bond. It will take time to obtain that bond. For larger projects, for larger receivables, larger contracts, it's something you should keep in mind if you do want to serve the stop payment notice that is bonded. And then the lawsuit deadline for the stop payment claim is 3 months after the deadline for filing a mechanics lien. And the deadline for filing a mechanics lien is 120 days after completion of the project, with some exceptions. Now, we want to briefly turn to public projects. These are projects that are owned by public entities, cities, towns, counties, states, potentially the federal government. It is against public policy to file a lien on a public project because we do not want contractors foreclosing on grade schools. And so because lien rights do not apply to public projects, most states and federal projects will require the general contractor to obtain a bond. So the general contractor is the one taking this bond out. Okay, they're the ones that are paying for this bond. And they typically have some type of indemnification agreement with the surety or the bonding company. But that bond is in place for the lower tier subs because they cannot assert a claim, a lien claim on the property. They have the ability to assert a claim against the bond for the contract amount in most cases. It's important to know in the beginning what type of public project it is and who the owner is. As Lauren touched upon briefly, we are seeing more and more of these public-private partnerships, which are these hybrids. The law is muddy as can be in most cases as to what your rights are, but in those cases you have a government entity that owns the property that will enter into a long-term lease with a private entity, and then that entity will build something on that property. Do you have bond rights? Do you have lien rights? You need to know who the owner is and how to proceed. Same is true for the federal projects. Some of these are relatively straightforward. If you are doing work at an Air Force base, that is likely to be a federal project. In that case, the general contractor is required to post a payment bond if the entire contract amount, not just your portion as a sub, but if the entire contract amount is over $100,000. There are two types of bonds. I don't want to confuse the issue here, but when a general contractor is required to provide a bond, there is a payment bond that protects their subs and suppliers. And then there's a performance bond that is usually required in conjunction with that will protect the owner in the event of a default by the prime contractor. The surety in that case would be required to finish the project as a result of that performance bond if the general defaults, absconds with the money, leaves the country, whatever. On a federal project, you have the ability to assert a claim if your contract is with the general contractor or a subcontractor. Any lower than that, you do not have a right on a federal project. There is no preliminary notice required, but your final claim must be filed or served within 90 days, and the lawsuit must be filed within 1 year. Now, moving to Arizona, similar to federal projects, Arizona statutes require that the general contractor post a payment bond. Payment bond will, rights exist if you have a contract with the general contractor or a subcontractor of the general contractor. I think one takeaway here is that it's clear that in Arizona, you do not have lien or bond rights if you sell materials to a material supplier. You're too far removed to have any lien or bond rights. If your contract is with the general contractor, you do not need to serve a preliminary notice. You can. That doesn't hurt your claim. That doesn't invalidate your claim, but it's not required. If your contract is not direct with the general contractor, a 20-day notice, very similar to lien requirements, a 20-day preliminary notice is required to be served on the owner, general contractor, and surety. Again, this is Arizona lien laws do allow you to serve that notice late, but it only preserves your bond claim for materials and labor you provide 20 days prior to that notice and anything provided thereafter. Unfortunately, the 20% rule applies to bond claims, which means that you are required in the preliminary notice to note the amount of your contract. It's like any good construction project. If there are change orders along the way and your contract increases by more than 20% of the initial contract value, you're required to send out notice again of that new contract amount to the parties above you in the chain. So it is a very strange caveat with regard to Arizona that you need to be aware that if you send out the preliminary notice, if your contract increases, you may need to send out a new notice stating that that new contract amount. With regard to, so you're at the end of the project, you've got, you're not paid. What are your requirements on a bond claim for a public project? You are not required to send out final notice if your contract is with the GC. We do recommend sending out notice, even though it's not required. What this does is it puts the surety on notice that you've got a claim for monies owed on this project, and potentially get it resolved voluntarily without the need for suit. If your contract is with a subcontractor, you must give final notice, serve final notice within 90 days of your last date. As Gregory and his team at Nationwide will tell you, do not wait until the end, and be cautious what that last date is. The example that I generally use is you cannot be off-site for a couple of months, deliver the proverbial doorknob or other, smaller item, and hope that it increases your deadline to serve the final notice. It will not. Your last date is typically your last date of substance on the project. So just be cautious with regard to what you use as your last dates on the project. On a public project, when a bond is provided, your lawsuit deadline is 1 year from your last date on the project. Not completion, not any other deadlines, it's your last dates on the project. So, Gregory, I know that I went a little bit quick on that, but you wanted 10 minutes reserved for questions, and that is what I tried to do.
Well, you did a fantastic job. I'm looking at my clock, and I didn't have to cut you off, so it's appreciated.
Good.
This is an opportunity for all who are in attendance to click on your icon. You can type in questions for our presenters based on information that you may want regarding the Arizona lien law. I see a hand is raised, and again, you need not raise the hand. If you click on your icon, it should give you the opportunity to type in your question. That question will be read by our panelists, by our presenters, and then answered. I just saw someone just raise their hand, and give you an opportunity again to click on your icon. There we go. We have a question. Can we collect fees from owner for expenses?
For expenses related, I'm assuming that's related to a foreclosure action, if it comes down to it. You can always request the fees if you're trying to resolve something, the lien claim direct with the owner. But if you do have to file a lawsuit to foreclose on your lien, Arizona does allow you to be awarded reasonable attorney fees as a result of that foreclosure action. Some states don't, some states do. In this case, you may be entitled to recover reasonable attorney fees if you need to file a foreclosure action.
In this particular case, the same question is per lien and lien costs as far as collecting fees.
Yes, yeah. So usually if you file a foreclosure action, you would be entitled, if it resulted in a judgment, you'd be entitled to include those costs in your underlying judgment amount.
Okay. Thank you. I hope that definitely answered your question. Please feel free, guys, if there's any difficulty in asking questions, you can make me aware. I know some of you are tied in by phone, and I can make it available for you to ask the questions live. But with that, again, if you just click on your icon, you will see an opportunity for you to type in any questions that you may have. We encourage the questions to be asked. While we're looking at that, I did have a question for our panelists. Going back to when an Arizona mechanics lien claim should be filed, can you guys reiterate? when should an Arizona mechanics lien claim be filed?
Yeah, I can jump in, Gregory. So if we go back to the slide involving our deadlines, it's 120 days from the last furnishing of labor and materials. So when you're last on site, you've got 120 days. That's the default that we use. However, if there is, because it's 120 days after the completion of the project. So completion is defined as 30 days after final inspection and acceptance by the governmental body that issued the building permit, or if there's a 60-day lap where no one's working on the project. If either of those two things occur, you start your deadline of 120 days, or you start to toll 120 days, and that's the time frame in which you must file your lien. Now, that can always be cut short because the notice of completion could be filed at the courthouse by the owner, and then that shrinks it to 60 days. You will get that notice sent to you by the owner because they have an obligation to do that within 15 days of filing at the courthouse. So it could be that you don't get that until 15 days after that, and then you've got 45 days to file your lien. But that's if the owner files the notice of completion at the courthouse. They may not do that. So 120 days after completion of the project, we want to say calendar your file for what's your last date of furnishing substantial labor materials, not that like last little hammer to the door or whatever it is. So you're trying to create a new last date. No, your real legitimate last date with a substantial invoice connected.
Okay, appreciate that. Also, another question is a written contract needed in order to file an Arizona mechanics lien claim?
Sorry, Lauren. No, to my knowledge, it's not. I mean, it's not typical, but you still have, a claim. The difficulty there is what's your contract price, right? You need to include that in there in the preliminary notice, and obviously in the lien filing. And is there an agreement there as far as what the price is? Will it be contested by your customer? It is not something that I have seen in Arizona as far as filing a lien without a contract. But I would say the biggest issue in Arizona is, defining the terms of your contract price, as that is required to be included in the preliminary notice and the lien filing, obviously.
Okay, thank you for that. And again, we do invite our attendees, if you do have any questions, please feel free to ask. I am going to step back for a second and again ask another question with regards to the stop notice. I know that you did touch on that, and I think it's important maybe to reiterate what is that Arizona stop notice and why should it be filed?
Yeah, so the notice is served initially, and that will, that may tie up the funds that are on the project to be released to the parties above you. Obviously, upon receiving any notice of the lien, that does not prevent the owner and lender to release funds. They may still do so, but it doesn't necessarily prevent them. What a stop notice does is it may prevent the flow of the funds. You want to trap those funds as soon as you can if there's an issue on the project, because if those funds reach your customer and you have not preserved your rights, be it mechanics lien, stop payment notice, then you are left back at square one with a contract claim against your customer. So the whole purpose here of the lien, the bond, the stop payment notice, you're looking at other avenues for payment. You're looking at other parties that can make you whole on a project. If you just ignore everything we just discussed in the last hour, you are always going to have a contract claim against your customer in the event of non-payment. But what you're doing by looking at these other remedies is you are looking to other parties to pursue for payment. And with that stop payment notice, Gregory, just to go back to your original question, you may freeze the funds and force the parties above your customer to deal with your stop payment notice and the reasons for non-payment before those funds hit your customer.
Fantastic. I truly appreciate it. Well, with that being said, we are at the end of our presentation. We do like to thank our guests, Lauren Skildum of Wagner, Falconer and Judd, as well as Daniel Reich of Wagner, Falconer and Judd. Truly appreciate the time that you're taking out of your busy schedules to provide us with such needed information with regards to the lien laws in the state of Arizona. For questions not addressed during this webinar, all are welcome to submit your questions directly to Wagner, Falconer and Judd. The email address is provided below, liengroup@wfjlawfirm.com. Again, that is liengroup@wfjlawfirm.com. Also, we would like to announce that our next free webinar series will address lien laws for the state of Florida. So bring tanning oil. This is scheduled to take place June 26, 2019, 1 p.m. Central Standard Time. We will be sending out invitations for everyone to join us and participate. Florida has been in demand, and we do like to meet the demands of our clients with regards to any questions or concerns that they have regarding the lien laws. And once again, just want to say, any questions that was not addressed that you may have for our panelists, you can definitely email them at liengroup@wfjlawfirm.com. We'd like to thank all for joining us today. We will now let you go back to your busy work schedules. Again, we look forward to your participation at our next webinar series. Thank you, Lauren. Thank you, Wagner, Falconer and Judd, and have a great day, everyone.
Thank you. It's a pleasure.
Bye-bye.